Honorable, the Supreme Court.
Good morning, everybody. Thank you very much. Please be seated. Please call the case.
Good morning, Your Honors. The matter before the court today is the case entitled In Re Wheeler Parcel Act 250 determination, case number 24 AP 239. The appellants here today are Alan Lozado, representing the Villas at Water Tower Hill Homeowners Association, Jeannie Zagurski, representing the Neighbors Committee Against Neighborhood Blasting, and James Mark Lees. They represent themselves and will be splitting time. Representing Appellee Jam Golf LLC is attorney Christopher Roy. Thank you.
Okay. All right. So, folks, you're going to split up your time. How much time? Just give me an idea. How much time are you each going to? Mr. Lee's going to take most of the time, huh? You each have 5 minutes? No more than 5 minutes. And the lights, you're going to turn the light on? It's going to be a hard, solid light to let them know that you've hit the wall, right? Huh? Okay. All right. You know, you can reserve time for rebuttal. You got that opportunity, but it's up to you. We're not going to help you with that. Okay. You've got to stop yourselves from talking. We're not going to do that. Okay. So Mr. Lees, come on up here. I know you're an attorney.
My name is Alan Lozado.
Oh, you're Lees.
Yes.
Oh, what's your name?
Alan Lozado. I'm the head of the home.
Thank you, Mr. Lozado. And this is Ann, your name? Okay. And you're Mr. Lees? You're admitted in Vermont?
Yes.
I just want to make sure. Are you an attorney?
No, sir.
And
No,
are
sir.
you? Okay. All right. All right. I just want the record to be clear about that. And so start the time now and please go ahead, sir.
Good morning, Your Honors. I just want to give you a brief statement. I enjoy walking on the recreation paths next to the Wheeler parcel and wide trail crossing it, where I have spectacular views of the Green Mountains, including Mount Mansfield across magnificent open fields. The Wheeler parcel is like the privately owned Vermont National Golf Course, Parkland, across the street, but with this difference. Unlike the golf course private parkland, where housing has always been allowed, the Wheeler parcel, along with the rest of the Wheeler Nature Park, has long been protected as a nature park and designed natural area. It is land that the South Burlington City intends to be preserved in perpetuity by a third-party conservation easement with unpaved walking trails, the only type of improvement to be constructed on the property, as stated in the 2016 South Burlington Comprehensive Plan. Through the Vermont Land Trust, the city did actually conserve the land that it owns on December 3rd, 2024. The recreation path alongside the Wheeler parcel is always busy with pedestrians, bikers, exercisers, and baby strollers. People of all ages come by foot, bicycle, and car. I can see them from my property, which is just across the street. If this development is built, the views of the Green Mountains will be blocked by the buildings and the natural scenic beauty of the parkland destroyed. South Burlington is rapidly building very high density housing with large developments on Spear Street, Kennedy Drive, and the city center. All this new housing and designated growth centers makes this project on a nature parkland absolutely unnecessary.
When you say high density, do you know how many, I was trying to figure out on the single family homes that are part of this project or proposed project, how many acres? It seems like it was a very small amount of land.
It's about this project proposes about 6 acres.
6 acres total though.
6
And then-
acres total.
So if I was to buy a house in this 6 acre development, how much acreage would go with that one specific house?
A very small amount,
I
I
mean,
mean, quarter acre, maybe. It's going to be a homeowners association, I assume.
so it's all done by a,
Yeah, and I'm
I
almost
know.
done, so. All this housing and designated growth centers makes this project on a nature parkland absolutely unnecessary. It is shocking and offensive to me, an average person. The Wheeler Parcel project would establish a terrible precedent for this court, I believe. Please deny the permit. I thank you.
All right, thank you. We'll hear next. Please come on up. Introduce yourself for the record, if you would, please.
Yes, my name is Jeannie Zagorski, and I represent Neighbors Committee Against Neighborhood Blasting.
Thank you.
So, my house is the closest house to the Wheeler parcel. It's about 250 feet away. The Wheeler parcel has recreation paths on two sides, the Dorset Street side and the Park Road side. From the Dorset Street side, I see beautiful views of the Green Mountains across the open field of the Wheeler Nature Park. Wheeler parcel, sorry. The walking trails are wonderfully peaceful and I have beautiful nature and wildlife surrounding every trail. And I enjoy riding my bike, as do others, on the recreation paths every spring, summer, and fall. So if the project is built in the Wheeler parcel, it will ruin the last remaining view of the Green Mountains from the recreation path along Dorset Street in South Burlington. There will also be ongoing drilling and blasting Monday through Saturday, all day long during late daylight hours, which is when the park is most used. There will be noise from top hammer drilling at 124 decibels at the drill site and 95 decibels on the recreation paths, and even louder noise from blasting at 133 decibels from each blast on the recreation path, where people will be held up by fly rock monitors up to 250 feet away. All this noise will destroy the peacefulness on the walking trails and the bike paths, since they will be out of commission during every blast and the all day long drilling 6 days a week. Additionally, 60 of our neighbors stepped up to be fact witnesses, and 20 of those 60 testified in Superior Court in support of stopping the build out in the Wheeler parcel. Under Criterion 10, the South Burlington City Plan makes strong points about protecting wildlife in this nature park. Specifically, the 100-acre Wheeler Nature Park has been documented as one of the most important areas of wildlife habitat in the city. Also, Alan Strong, UVM wildlife experts' testimony stated that wildlife will be negatively affected in the nature park if this project moves forward. Noise from blasting, drilling, and machinery will cause habitat fragmentation and habitat loss because of the inability to breed. And this is especially concerning since some of the species in this park, have been identified as endangered. After the construction is complete, Wheeler Nature Park will never be the same. The beautiful views from the recreation path will be completely blocked by the high density residential build out of the 32 homes. And the walking trails and wildlife surrounding the parcel will be gone. The city plan stated that the Wheeler Nature Park, including the Wheeler parcel, was to remain as a nature park forever in perpetuity by conservation easement to safeguard the park as a whole, and that there would be no improvements beyond unpaved walking trails. So it is my hope that Act 250 prevails and protects the subdivided Wheeler parcel so it continues to be a privately owned, designated natural area and nature park. So I do ask you to please deny the permit. Thank you for your time.
Thank you very much. We'll hear from council now, please. Please introduce yourself.
My name is James Mark Lees.
Let's see how much time you have, Mr. Lees.
7 minutes and 44 seconds.
Okay, I'd like to reserve the rest of the time for rebuttal. We can rely on the briefs for legal arguments.
All right, all right. Thank you very much. So we'll hear from counsel for the appellee then, please, and If you would, for the record, introduce yourself, identify your client, and then proceed.
Thank you, Your Honor. My name is Christopher Roy, and I represent the appellee in this matter, Jam Golf LLC. And the appeal before the court will determine whether a modest residential project in suburban South Burlington on a parcel that's been specifically planned by the community for residential development and approved by the city's Development Review Board should be affirmed after the Act 250 application at issue was approved by both the District Commission and the Environmental Division.
When we use the word modest, it's 32 units, some single-family homes, some duplexes.
Correct.
On a 6-acre parcel
It's
of
a,
land, which seems to me that that's high density, that there's a lot of homes going to go onto a fairly small parcel of land. So how do you consider that to be modest in the amount of homes that are there?
well, modest can refer to many things. Here, modest is, it addresses what's called in housing circles the missing middle. These are not the large single-family homes that ring the Vermont National Country Club elsewhere in the vicinity. The city identified a specific size and type of housing with a particular price point that it wanted built on this parcel.
Okay, so you're not talking about the volume of the density of the housing itself. It's just, it's not for the 1%.
Well, and it's also only 32 units. It's not like a massive 150 unit multi-phase subdivision, as you know, this court considers from time to time. It works out to just under a quarter acre per dwelling unit. They're single family and duplex homes. The city dictated with a remarkable amount of detail the precise design requirements and locations of these buildings in order to minimize the impact on views. It required only single-family homes at particularly prominent locations in order to preserve that view. And so this is really a matter that the city council, the planning commission, and others responsible for land use planning within South Burlington have put a lot of time and thought to.
And there's a 2-story maximum? Did I read that
Yes,
correctly?
and that's for about 2/3 of the buildings. There are certain buildings that are only 1 story.
Mr. Roy, can I take you in a different direction?
Absolutely.
Before you go back to your notes. This issue of the 2016 city plan versus the 2024 city plan, am I right to understand that the 2016 plan would not have permitted this development?
No, Your Honor. In fact, the District Commission did not have the 2024 plan in front of it and approved this project with reference to the 2016 plan.
I see. But the trial court, the environmental court, applied the 2024 plan. Am I
Correct.
right? And did so, and this is what I want to ask you about, applying an exception to the vested rights doctrine
Correct.
in order to do so. Now, I looked, and you know, I may be misremembering. I may not have thoroughly evaluated everything you wrote. I think all I saw were citations in your briefing to environmental court decisions in support of the trial court applying this exception. Am I right about that?
Correct. This court.
So this
not
court
addressed
has never ruled on that.
That
Can
is
you
correct.
give us some context for why you think we should adopt this exception to the vested rights doctrine in this matter? Can you give us some context
Sure.
to that beyond environmental court decisions? That's what I'm.
Understood. And Judge Walsh took some pains both at the trial and in his written decision to address the practicalities of that.
Yeah.
If you have a chain and revisions to comprehensive town plans or regional plans are multi-year processes, and they involve planning over the whole community. So it's really a lengthy process. What the environmental board formerly, and now the environmental court, has agreed is that if that process, for lack of a better term, catches up to a project and provides a more favorable plan for the project, that the court or the former environmental board were not going to, and this is in a circumstance, let's say, where the former plan would have prohibited the project and the new plan approves it, which isn't the case here, but how this developed.
And that's your position, but I know the appellant sees it
Sure.
differently. Right.
So the rationale is it makes no sense from a substantive and judicial economy perspective to require the applicant to go back to the beginning, resubmit the same application in order to
So
take advantage of it.
That's the total rationale, right?
That
The
is.
rationale is efficiency.
Correct.
The rationale says, we don't want to make the applicant for this permit to have to go back to square one and refile, because that's what they will do if we don't adopt this exception. They'll
Correct.
simply go back and refile, and we're going to have to take up a time for the parties and for counsel and redo all of this. Instead of that, we're gonna allow you, we're gonna proceed in this fashion. So it's entirely an efficiency and sort of practicality rationale,
Correct.
right?
Correct.
Have you got authority from other jurisdictions where they've reviewed this?
No, not specifically. In Vermont's vested has the minority position regarding vested rights anyway, so then that shrinks the opportunities for that. Not any that deal with the same situation here, where Vermont has a process of multi-year comprehensive plans that are revisited periodically every 8
Well,
years.
then can you point to other case law that we have decided, that this court has decided, where the same sort of principle of rationality, if I could call it that, judicial efficiency, it's really not just judicial efficiency, it's efficiency for everybody, but where we have applied it in the environmental law?
Well, the Eastview decision by Judge Durkin was appealed to this court, and neither party thought that the application of this rule was remarkable enough to raise it as an issue before this court. So that's the one time that issue has come up here. To be honest, I can't tell you off the tip of my tongue other cases in other
But
locations.
what about the statutory framework that the legislature has passed? Can you point to provisions in the environmental law that act similarly to accomplish the same kind of a purpose of practicality, of efficiency?
Not right now. If Your Honor would like me to, I could.
Well, you're free to supplement, sure.
Yeah.
Okay.
With respect, and it's an important issue because the community planning process is designed by statute in practice to involve all stakeholders within the community. You have multiple meetings that lead to studies, that lead to drafts, that lead to an ultimate plan, and it's a multi-year process. The 2024 plan first started in 2022. And it is a reflection of the community's current thinking about what they would like land use to be going forward in their community. The rule that the appellants would have apply here would essentially turn that on its head and freeze planning in amber when the neighbors want that, yet the community has gone through that iterative process of updating their plan. So for instance, in this case, there was an exchange of land, 6.91 acres, which is in the corner of Dorset Street and Park Road and doesn't have as much value from an environmental perspective, was exchanged for over 20 acres along a ridge line that provided more land and of a higher environmental quality. And the city, employing its responsibility to govern its parkland, decided the park would be better off with that 20 acres in hand and allowed development on those 6 acres. And the irony here is literally the land that is now part of the park happens to be land that's behind Attorney Lee's home. So right now, he is benefited by new parkland conveyed by Jam Golf that's along the back of his house and can't be developed because it's now part of Wheeler Park. And in the meantime, they are arguing that development cannot take place.
Were there conservation easements in the Wheeler Park? Were there conservation easements that restrained you or constrained you from changing the rules as was called for in your 2015 agreement, settlement agreement?
Yeah, and to be honest, I was not involved in that. There
Well, yeah,
was
but can you tell us as a matter of what the record says?
right, and you have the amended consent order that was approved, the
Did
settlement
were there conservation easements?
over some of the land, not all of it.
How about this parcel?
I do not believe so, but I am not positive. And again,
So the other, this whole notion of unclean hands, which is a very sort of novel idea, it's something I never would have thought of myself, but I give credit to the appellants for arguing a construction of the record in this way. Let me ask you this, is there any question in your mind as to whether or not the city followed due process requirements throughout in amending its bylaws with respect to the zoning requirements on this lot?
I think every T was crossed and I was dotted. This was an extremely.
Were you involved in that?
No, I was not, but I have had the opportunity to go back and review it.
Yeah.
And as your honors will recall, Jam Golf was back in front of this court back in the early 2000s.
Right.
This settlement was an upshot after that decision. It then went back to the city and very complicated negotiations took place that resolved all of the outstanding issues between the two. And with respect to unclean hands, I know that is directed at least partially to whether data or information in the application was ultimately found not to be the case. As your honors know, you frequently in Act 250 matters will add more to the record, will correct statements in the record, and then ultimately the appeal to the environmental division is de novo. And so all of that is fresh. All information can be presented anew. So we don't really think if there ever could be a circumstance where unclean hands would apply to a proceeding like this. This is not the circumstance to apply it. One last issue I would like to mention briefly that I do think is important is that much of what the appellants are arguing is asking this court to reweigh the evidence that was in front of Judge Walsh. This court in Kessenbach and Lathrop and other cases has made it very clear that factual findings by the trial court will be affirmed if there's any reasonable support. Truly legal questions are reviewed de novo. But in cases where you are applying legal standards or criteria to facts, this court applies a deferential standard as long as there is evidence that supports the conclusion that's ultimately reached. In this case, this part I was involved in, it involved a surfeit of process. It was a very long trial. It was multiple days. There was a lot of motion practice. There was a lot of briefing. Everything that could possibly have been presented was, and Judge Walsh took the time to write a very comprehensive decision weighing all that evidence. There's no doubt but that appellants wish that Judge Walsh would have come out differently on many of those issues. But of course, that's not the question that's before this court. The question is whether there was a sufficient evidentiary record upon which the trial judge could premise his comprehensive decision. And Jam Golf asserts that that record is adequate by far and that the court's decision should be affirmed in all respects. Thank you very much.
Okay, thank you. Mr. Lees, come on back up and let's just reconnect about the amount of time you've got. How much time, please?
Appellant has 7 minutes and 29 seconds remaining.
Okay, please go ahead.
Okay, thank you very much, Your Honor. As for the 2024 city plan, I'd just like to reply that it was not duly adopted for a lack of a 4384C report on the Wheeler Parcel project. So it had 5 or 6 other types of amendments from the 2016 to the 2024 city plan. But the one that's at issue here, and that the city knew was at issue here, is the one at stake. It was not mentioned, and there's nothing in the existing 4384C report. We thought maybe they're going to come out with another one because this is such an important area of controversy, but the city never did. So the 2024 plan lacks the review under 4302, which goes into that 4384C report. And here we have a project that's totally recreational in nature, not just the recreation path on the 2 sides and the rest of the Wheeler Nature Park on the other 2 sides, but also the land itself is parkland because of the 2017 permit, which has the conditions that there's no change in the design, operation, or use of this land and no alteration until the decision is made about an amendment to the permit. And also we have the issue of the fact that this is a sequential permit amendment application. And all the information, the 32-unit development was known in 2015 when the city and JAM made their agreement. And that agreement, as Your Honor pointed out, required the city to amend its bylaws in compliance with the deal, not in compliance with the 2016.
Do you claim, or do you have any evidence that the city did not follow ordinary due process procedures to amend its zoning bylaw?
The city, yes, the city.
You claim that?
The city did not follow okay, so there's several pieces of evidence. First of all, the city planner testified that the regulation, that the 2024 city plan was amended to comply with the regulation that had been adopted in 2016. And then the 2016 amendment to the bylaws was in compliance with the deal. Now, how do I show that? Because the city plan prohibits its parkland. It was city owned.
But I think the question is, and I'm not sure you answered it, or at least I'm not getting that. The 2024 amendment went through the processes that are required to amend a portion of the city plan, right? I mean, they didn't just.
Everything except this issue. The 2024 plan is fine for everything except the Wheeler parcel because there's no 4384, and that's.
What do you mean there's no 43? Tell me what that means.
There's no mention of the amendment to the city plan for the area of the Wheeler parcel in the existing 4384C report. And there's no other 4384C report for this parcel. So it didn't get the due process to be a city plan.
Well, was notice given that this was going to be a part of the 2024 amendment? Was notice given prior to the procedures that initiated to amend? What was notice given?
Yes.
That was a portion of the amendment involving this issue.
And 36 neighbors submitted emails
Okay.
to the planning commission saying, please don't amend it and keep the text from the 2016 plan. And I went to that meeting and we had the discussion. But then when the 4384C came out, there's nothing in it about the amendment to the area of the Wheeler parcel. So this 2024 city plan may be fine for the various other amendments, but how can it be used to consider this, this application, this project, when there was no 4384C report.
So can the appellee go back today and make a new petition for on the 2024 plan for building?
No, because the whole process was deeply illegal. And that's probably why they didn't make this report. They just didn't want to deal with it. They started with amending the regulation. The normal process would have been to amend the city plan. They have a deal with the developer. Fine, we amend the city plan. We go through the whole process of public involvement to amend the city plan. Then we amend the regulation in compliance with that amended city plan. But they didn't do that. They skipped the amending the city plan part of the project. And instead, what we have is the city plan. Whatever people, all this input was ignored. It was just to comply the 2024 city plan to the deal and the amendment to the regulation. And that's in the testimony in the case that one of the members of the planning commission, Smith, his name is Laurie Smith, and he's now on the city council. He testified that, yeah, it was the attorney, the city attorney requested that we have a deal with the developer, that we should make good on our deal. And that was why this one map in the 2024 plan was changed. There's another map that they didn't change. It shows the whole park undelineated. So the city was not for doing this. This was just to comply with the deal so they wouldn't be back in court or whatever the reason. The city didn't want to be sued by JAM for not doing its part. And they wanted to be upright and do what they were expected to do under the deal. But that undercut the due process, because any input they got from the citizens is ignored because they have to comply with the deal. So this whole thing.
You're really arguing that the 2024 plan is invalid, right?
Totally, for this
That's
project.
not the issue before the court today. That's a different process. If you wanted to challenge the plan itself, this is not the case for that, right? This is not an appeal of the town plan.
This is the reason that this is under the unclean hands issue, because this is a continuation of the process that started with the deal to amend the regulation without complying. That whole regulation violates in re Melgano 4401, 4410, 4411, and 4441A. It should not have happened that way. And now that in addition, this is what's happening during pendency of this appeal. It's not just in 2015 and 2016 that they did violations. This happens during 2024 as well.
Sorry, go ahead.
So, a question. What are you saying becomes of the deal? If you're to prevail?
We don't challenge the deal. We don't challenge anything. The only thing we're challenging is the Act 250 approval. Because these bad things happened, they should not be allowed.
Yep. Your time is up. Thank you very much. Your time has expired. Please call the conclusion of the hearing.
That concludes